Hear ye, hear ye, hear ye. The Court of Appeals for the 14th District of Texas is now in session. Soon to adjourn. God save the Constitution and the court.
Please be seated if that's appropriate in this case. Welcome to the 14th Court of Appeals. And if this were the before times, we might very well have had this case in Galveston. But for those of you who work in the Galveston area, remind us that we said we'd come visit sometime. But moving on, the case before the court today is West Gulf Marine Limited versus the Texas Land Office and Commissioner George P. Bush, 1419-00708 CV. Can I get announcements from counsel?
This is Robert Booth for the appellant, West Gulf.
Are you going to reserve any time, Mr. Booth?
Yes, Your Honor, I'd reserve 3 minutes.
Okay, thank you. Appellee?
Natalie Thompson for the appellees.
All right. Y'all may proceed.
May it please the court. The crux of this appeal is that this court should adopt the reasoning in United States versus 772.4 acres of land, which holds that the Republic of Texas conveyed submerged lands when it auctioned portside lots on Galveston Island to pay for debts incurred during the Texas Revolution. Appellate West Gulf is the record owner of 2 of those auctioned lots, which border the port in Galveston. West Gulf is a shipyard that has operated since the 1970s. This suit is very important to West Gulf's ability to continue business and to grow. Incidentally, through the magic of video teleconferencing, as Justice Spain had just mentioned, I'm actually coming to you today from Galveston Island, where I can look out my window and see the port. But here, the trial court erred in dismissing West Gulf's claims for lack of subject matter jurisdiction. West Gulf seeks an order reversing the trial court's decision and remanding the case for a jury trial on the merits, because West Gulf defeats the presumption that the state owns the submerged property at issue. Turning to the argument.
Is this an interlocutory appeal or a conventional appeal?
Yes, Your Honor. So in our statement of jurisdiction, we address that issue. We took the position that there's no remaining issues to be handled at the trial court, that this is, either way, it's a timely appeal and this court has jurisdiction. And so we take the position that if the court were to reverse and remand, then we would have a trial. But if the court were to uphold the plea to the jurisdiction, then the entire case would be resolved. But turning to the argument, in the city of Galveston versus Menard, the Texas Supreme Court established a test to show that the legislature intended to convey submerged property. That test is whether the conveyance is, quote, not an ordinary sale or donation of land that as upon a certificate of scrip for indefinite purposes, but was a specific grant directly made by the government for a specific object, and it must be understood and construed with reference to that object. And that's at the city of Galveston versus Menard case at page 397. And so the history lesson, which I'm sure the court is well aware of, is that in 1836, the Republic of Texas, of course, this predates the formation of the state of Texas, the legislature for the Republic of Texas passed a law directing that the whole of Galveston Island be reserved and that the public lands be severed from the public domain. This meant that the island lost the character of public lands, and that has been decided in the Delis Denier case in 1849. Then in 1837, the legislature for the Republic of Texas passed a law directing that the whole of Galveston Island be surveyed and divided into lots between 10 and 40 acres. A copy of that resolution is found at Clerk's Record 166. This legislation provided for the auctions that was passed only months after the Menard grant, which the court is well aware conveyed submerged property.
Mr. Booth, I'm interested in hearing about 2 specific things. One is that there's a contention by the state of Texas that Anibra Foster Townsend, who was an expert on their behalf, established that the state of Texas owned the submerged land lying within the original boundaries of lots 30 and 31. Is there anything in the record that shows us that that expert testimony was rebutted somehow by your client?
Yes, Your Honor. That opinion is based upon looking at the maps, the Trimble map and the Phelan map, We actually have an opposing expert who attached his report. And in that report, the expert went through and talked about how there are not mets and bounds, but there is a specific call to the acreage. And around the time of the 1900s, the deed chain for this property started to have mets and bounds descriptions. And when that started happening, that meant that those calls specifically went out into the water of the bay. And that opinion is at Clerk's Record 175.
And my other question, in which if you wouldn't mind helping me with this,
You bet.
there are presumptions regarding the submerged land. And I'd like you to direct our court to any evidence in the record, testimony in the record, regarding the presumption that the state has not acted to divest itself of the title to the submerged land.
So the best evidence of that is the acts that we cite from the Republic of Texas, and those are at Clerk's Record 166. And if you look at that language and you look at the purpose of why this property was sold at auction, was to pay debts, and then specifically that act says we're going to divide Galveston into lots of 10 to 40 acres. Okay. If you look at our lots as they exist today, they are less than 10 acres. And so given that the enabling act said it's got to be 10 acres, that necessarily means it goes out into the water. And so we believe that evidence rebuts the presumption. Additionally, the evidence from the landman, which shows that it's a call to acreage would necessarily mean that the title to the property would have to go out into the submerged waters.
So is there anything else you want to direct us to other than the enabling act and the proposition that the less than 10 acres rebuts that presumption?
There is attached to in the record, there are the leases that were signed with the General Land Office. There is a reservation under that lease, which where the parties reserve rights for West Gulf to retain. Attached there are maps of the property, which show that the current boundary, the bulkhead basically of the port, and kind of can describe the property, which would also necessarily show that in order to get to the call to acreage, in this case, you would have to go out into the water. And of course, Your Honor, I'd be remiss if I didn't point to the initial grants to Thomas Chambers and Mr. O'Brien, which have the specific call to the 13 acres.
But as your client's alleged ownership rights in the submerged land is decreased, isn't it true that there is land that is added to comprise the 10 acres to the lot or lots, excuse me, that is not submerged land?
Maybe I'm not understanding. There is less than 10 acres, which is dry land, and that
Right.
to get to 10 acres, you'd have to include the submerged land. And I would also say that another reason that we think that the submerged land was conveyed is because the Menard grant the Supreme Court has held did convey submerged land. And just as the court in the U.S. the Southern District for Texas has held, that this is more like the Menard grant, which would convey the submerged property. Remember, the acts at this issue, in this case, were mere months after the Menard grant was made. And so I think it's evidence that it conveyed that the intent of the Republic of Texas to convey submerged property along the bay side. We're not talking about submerged property along the beach side facing the Gulf. There's been some suggestion that this case would somehow give new causes of action to a bunch of claimants. This is really only going to affect a few, our clients' lots and maybe a few others about this very specific port side property that ties its ownership history back to the auction sales, which were enabled by the acts from the Republic of Texas. And so it's our argument that, this issue has really been decided by the Southern District of Texas. In that case, the United States versus Acres of Land case has a very detailed discussion and comparison of the Menard grant and these auction grants, and it held that these auction grants are more like the Menard grant, which would have conveyed the property. The reason that our deeds in this case have a call to acreage is because they're based on the Trimble and Lindsay map and the Phelan map, which don't have calls. There's no dispute about that, but there is a call to acreage. And what we would suggest is that is specific enough for the Republic of Texas to have divested itself of the submerged property. It's also important to note that when Texas severed this property from the public domain, it did not make a reservation in that enabling statute that the property that is submerged would revert back to the Republic. It did make a reservation that if an auction was won and the winning party did not pay, it would return. And so the Republic certainly considered a circumstance under which property, which could be sold and when it would return to the state, to the Republic. Here, it did not do that with respect to submerged property. And so given the history of these grants, we think that the court should hold that it's more like the Menard grant and that it was conveyed the submerged property. I do want to touch on just briefly, Your Honor, there is a whole line of cases dealing with the Jones and Hall grant. That's the severance decision. We're not seeking to disturb that. That is an entirely different, grant. It was, went through a very complicated history with the Della Steninghead case, which is validated and then reaffirmed by the state of Texas, and then ultimately ruled on the severance decision. This is really not that. And I think that that history of a patent being found to be invalid and then reaffirmed by the state is really evidence that our property, the West Gulf property, should not be treated like those lots. And it should be treated more like the Menard lots. And so this is a very unique issue. I don't believe that there has been a Texas appellate court decision squarely on point as to whether or not this auction process conveyed the submerged property. There is a court decision, this Southern District of Texas case, that does squarely fit on that fact pattern. And for those reasons, we would urge the court to adopt that reasoning. And so we see West Gulf seeks an order reversing the trial court's decision, remanding the case for a jury trial because West Gulf defeated the presumption that the state of Texas owns a submerged property. Thank you. And I yield back the rest of my time.
Thank you, counsel. We'll wait for our Zoom master to fix things.
Great.
Just as saying. West Gulf focuses on the 772 acres from the Southern District of Texas case. There are a number of reasons why that case is inapplicable here. The main one has to do with an important factual distinction between the issue that was discussed by the Southern District and the issue here. That case did not address portside lots as counsel represented. It addressed internal bayous on the island, many of which by 1944, when the case was decided, had already been filled up and for many years had been treated as part of the tracts of property. That makes sense in light of the Trimble and Lindsay survey. If you look at tab C of the appellee's appendix, that's the Trimble and Lindsay map, and it reflects survey lines that run across these internal bayous. Those are the lots that were at issue in 772, and that court had no reason to address the actual shoreline boundaries which border on the public trust. Moreover, of course, this is a federal district court decision. It's not binding on this court. It's not binding on any federal courts. And to the extent it is inconsistent with Texas law, it should of course be ignored because Texas law controls here, not a federal court's eerie guess. I'll now turn to counsel's other arguments as to how the presumption of state ownership might be rebutted. None of them is successful here. To begin with, the calls to acreage. You can see just in this record with contemporaneous drafts that surveys and patents essentially always include a call to acreage, but it's not that call to acreage that tells us what the land is. It's the meets and bounds in the survey. For example, in Trimble and Lindsay, the state recognized a league and a labor was what was to be granted to Menard, but that was not enough, the Supreme Court said, to convey the submerged land. The submerged land on the port side in the Menard grant was conveyed only because the patent drew meets and bounds going out 150 varas from the shore and running with the channel. That's what would be needed to rebut the presumption of state ownership, and that's absent here. These patents refer to acreage and nothing else. Without something that conveys property that's submerged, something to make it clear that the state intended to divest itself of that part of the public trust, then the presumption cannot be overcome. Similarly, with the legislature, or the Republic's Congress actually's reservation statute and the statute providing for the auctions, the reservation statute, of course, deals with Galveston Island's dry land. It doesn't say anything at all about coastline boundaries. So it doesn't tell us one way or the other what would happen to submerged land. And even if it did, as the court explained in great detail in the Delisdenier case, that simply has to do with scrip and whether or not land could be located and patented in the ordinary course. Now, the patents themselves also include no such reference to land running underwater. They refer to the call to acreage. And of course, the legislature instructed Trimble and Lindsay to survey lots of 10 to 40 acres, but they did that under the background legal presumption that the state does not divest itself of submerged land. At the time, there's no dispute that these lots were over 10 acres. They were 13 odd acres each. And
well,
the
let me ask you a question about that, counsel. Does the record reflect that lots were sold exactly in the acreage of the statute in question that Congress passed?
To begin with, yes, they were sold in accordance with the survey, which at the time, before there had been any coastline change, we presume would have been the acreage reflected in the patent's call to acreage. All of them, of course, had a call to acreage, not just West Gulf's lots. But of course, as the years go by, erosion and accretion can occur, the tide lines change naturally. And so these lots up and down both the bay side and the Gulf side of Galveston, many of them have changed shape. Many of them have lost land. As far as we know, some have gained land. And of course, it's the same on the port side as the Gulf side in these grants. They're all described as with a reference to a call to acreage and the lot number in the Trimble and Lindsay survey.
So if there's a variance between the acreage as a general matter in property law, if you get this description of the land and then it says it's X number of acres, and if there's a variance, which one controls?
The meets and bounds would control over the reference to the acreage.
But the patent doesn't have a meets and bounds in this case, correct?
Correct. It refers to the Trimble and Lindsay survey. So we have to look at that survey, and although we don't have a complete written out set of meets and bounds, that's been lost to history. We don't know whether there was one or whether it was just destroyed at some point. The Trimble and Lindsay map is the record that we have of that survey. And nothing on that map reflects an intent of the state to divest itself of the public trust when it conveyed the coastline properties depicted in that survey.
And from an evidence standpoint, is anybody disputing the map? I mean, where are we with the map?
No one's disputed it, Your Honor. The state's expert, who is a licensed surveyor who can determine state title to land, one of very few in the state, issued an opinion interpreting this map and all of the other legal documents that issue in the record, essentially applying law to facts. The expert for the other side, as counsel noted, is a landman. He opined that West Gulf has good title to whatever remains of lot 30 and 31, but he offered no useful opinion as to whether lots 30 and 31 include submerged land.
So there's really not, we're not disputing that this survey is wrong to use or anything like that. It's just how do we take this stuff and what do we do with it? Okay, thank you.
Exactly, Your Honor. Now, counsel also noted a theory that the Menard case created a test for how to determine whether submerged land is conveyed. It did not. The land quoted in Westgulf's brief and by counsel is a description of part of the court's reasoning for why portside land in the Menard grant, or I'm sorry, portside to be bayside land in the Menard grant was including submerged land. It's very explicit about it. The land goes out 150 varas from the usual shoreline. That doesn't create a test that applies to any case. It's just a description. And even if it did create a test, that test would look to the intended object that the grantee would use the land for. In Menard, of course, that was Menard and his partners developing the city and the port of Galveston. Here, the state, when it auctioned off property, did not care what Chambers or O'Brien or anybody else who purchased a lot was going to do with it. They were just selling the land to raise money. So this would just be, in the terms of the Menard court, an ordinary sale for indistinguishable purposes. They can use it for anything they want, unlike Menard. So that doesn't tell us anything. Similarly, with the 1836 reservation statute, removing the islands from the ability to locate, that doesn't say anything about whether submerged land is included in grants of land on islands. It doesn't say anything specific about islands, about Galveston or any other island in particular. It simply says that you cannot locate scrip. And that's the reason that the Jones and Hall grant had to be reaffirmed by the legislature. Now, the Jones and Hall grant is also instructive in this case, and it shows why the state did not divest itself of land off the coast. This 774 acres case actually observed that the Jones and Hall grant properties with survey lines crossing the internal bayous did include the submerged land, but it also didn't touch on the coastal land, the public trust land surrounding the island. And fortunately not, because it would have been overruled by the Texas Supreme Court later. The Texas Supreme Court made very clear in recently the Severance case and in some other cases that the Jones and Hall grant does not include submerged land on the bay side or the Gulf side. That, of course, makes sense. You can look at Appendix Tab J, which is that Jones and Hall patent describing the meets and bounds, and you'll see that it's a littoral grant. It follows the meanders of the bay, the coastline of the bay, all the way around that western end of Galveston Island. Council also noted the leases from the GLO and noted that their landman expert report observed that some deeds in the chain of title refer to land that he says at the time was submerged. Now, of course, a deed can't create an ownership interest that the grantor doesn't have. So that doesn't tell us anything. What we need to know is whether the patents giving title from the state to the first private owner conveyed this. Later deeds in the chain of title, to the extent they convey something that the grantor didn't own, are void. But of course, we don't dispute that Westgulf does have appropriate title to the landward dry ground portions of lots 30 and 31. Then the leases with the GLO, of course, they don't say anything about the presumption either. They were entered into under a reservation of rights, as my friend noted. So they don't tell us whether the state owns submerged land. The lease simply recognizes that Westgulf has this claim, but it nevertheless agrees to enter into a lease. Now, that's what it wants to do here. The reason the GLO proposed a new lease in 2015 is because Westgulf asked for it. Westgulf would like to dredge many, many more acres of land underneath Galveston Bay, and it would like to expand its operations in that way. And to be clear, the state is not preventing Westgulf from doing that. The state responded to that 2015 request with a proposed lease with new terms that would allow for the expanded greater dredging that West Gulf wants to engage in. So recognizing the state's title to the submerged land in no way will prevent West Gulf from continuing its business and continuing with this barge building in Galveston. It doesn't have anything to do with that. Your Honors, unless the court has further questions, I will yield the remainder of my time.
Well, I have a question, actually.
Yes.
So is it and maybe you all are, let me just try to ask it in a way that is completely understandable. So the land that you have, that dry land, that West Coast or the state would say, okay, this is West Coast dry land. Some of that land eventually becomes submerged land, correct? Based on the tides.
Yes.
So in determining meets and bounds, do those meets and bounds change in regard to the lease, in regard to what you claim is the title by West Gulf Marine? How does that work?
So the boundary moves by operation of law. There wouldn't necessarily be a document in the county records showing that the title has moved because there's no judicial action or anything that needs to take place. It's this centuries-old presumption. We get it originally from Spanish law, and it says that if erosion causes some of the land to become submerged based on the mean tides, then that becomes part of the public trust. That's something, of course, that West Gulf knew about when it purchased this land. And of course, its predecessors and interests too were aware of this long-standing legal presumption.
But that's just a presumption, correct?
It is.
So if you had a meets and bounds and definitively said, regardless of anything that happens, we're selling you that the sovereign sells that.
Yes, we have some, and there are examples of this. The Menard grant has been the focus in this case. On the base side, it did convey what the presumption would have included as public trust submerged land. And it did it very explicitly, 150 varas out from the shore. The Supreme Court's recent case in Bush v. Lone Oak also talks about a grant that included submerged land, although in a somewhat different context, not right on the coast. And in the survey there, the court noted that the survey lines crossed the bayou that was at issue. So they had actually, similarly to the Trimble and Lindsay internal bayous, there is an indication on the face of the grant, the survey itself, saying that the submerged land will be included in the grant. This court had a case like that too. The Kennedy v. Foreman case dealing with Surfside Beach also involved a patent, and it explicitly said that the patent was granting, quote, submerged flats. So when the Republic and the state later wants to convey submerged land, it's certainly able to do so. It hasn't done so here, though.
I'm sorry, Counselor, I didn't mean to interrupt you. Were you finished?
Yeah. Yes, Your Honor, of course.
Okay. So, and also I see that if we affirm the trial court's decision, your position is that we should remand to the trial court for the trespass to try title claim.
Your Honor, if I may answer.
Yes.
Thank you, Your Honor. Yes, so our understanding, based on the way we filed the plea to the jurisdiction, is that it only dealt with the submerged property. It didn't actually deal with this little strip of artificial fill, which is, although it is dry, may be technically belonging to the state. So we didn't file a plea having to do with that land and having an actual resolution of where the boundary lies. So from our perspective, that's unresolved. All that the plea to the jurisdiction will tell us is that the state owns the submerged portion of the property. Of course, it seems counsel is abandoning its quiet title claim as to the rest of that property. There aren't meets and bounds currently in existence. So, perhaps they're willing to live with that if the court should affirm. But As far as we know, our police simply didn't deal with that other portion of the property, and a quiet title action is supposed to resolve title as pled to the entire lot.
Thank you.
All right, I guess we'll invite counsel for the appellant back in. Thank you. Is there any, I know you gave up your time, or are you still sticking with that?
Oh, no, I meant the time for my 3 minute.
There you go.
Yeah. I apologize, Your Honor. I
No
misspoke.
problem.
I would appreciate just a few minutes to respond to some of the things that we just heard from opposing counsel. The first is that discussions about the Bush case, which dealt with navigable screens, or the city of Surfside, those are cases that are materially different. The major distinguishing factor here is that the enabling acts from the Republic of Texas involve statutes of the Republic that mention Galveston Island. And so that's a historical piece. Galveston was recognized as a very, very valuable port city at that time, and quite frankly still is. And that's why there was these specific statutes auctioning off this very valuable land to pay for the war debts incurred during the Texas Revolution. There was some discussion about the Mets and Bounds. I think both parties agree that the map at issue, the Trimble map, does not have Mets and Browns. They've been lost to history, I think, as it's been characterized by the state. But we do have some evidence, and I know from our landman, Mr. Horton, who says that he can look at the deeds that start in the 1900s, and they start to include calls specific Mets and Bounds, which is some evidence of the reality that's on the ground at the time. And it's his opinion that those calls, given the acreage, necessarily extend out into the bay. And so
Wouldn't those calls be in the patent?
There are no calls in the patent.
Okay.
And in fact, this is really not even a patent case, because there is an act saying, go divide Galveston into lots of 10 to 40 acres and auction off the lots. Galveston was severed from the public domain, so it's not like there were scripts or patents out there where people would go and just start, if they had a patent from the state of Texas to claim some amount of acreage, you could just go to Galveston. That actually wound up being the major issue in the Jones and Hall grant case. And so, and then also to kind of bring it back, is I think the court's really faced with the decision of, is the property for these auction lots more like Menard, or is it more like Jones and Hall? We think unquestionably it's more like Menard. And remember, Menard treated the Bayside Portside lots differently than the Beachside lots in recognition that property is very valuable. And of course, the Menard grant was passed mere months before the grant, in this case, setting up the auction process. And so clearly the legislature was talking about setting up a port and how that property was very valuable. And for those reasons, we asked the court to reverse. Thank you for your time.
Thank you, counsel. If we could get everyone back in. And so case is submitted. We appreciate the arguments of counsel. And I would just add that my understanding is back in the 19th century, there used to be way more lawyers per capita than there are now. It's because lawyers used to make their money litigating land title. So this is historical what's going on. So thank you, and we're adjourned.
Thank you very much.